Hello everyone, this is the video of Legal Studies, Class 12, Unit 2nd, and the topic is Law of Contract, and the topic under Law of Contract that today I am going to discuss, that is capacity to contract. It is one of the principles of contract. So what is the meaning of capacity to contract? Capacity basically talking about the eligibility to involve in a contract, to make a valid contract. So contract law defines certain provision in order to be eligible to be a person who can make a valid contract. So anyone cannot make the contract. So let's check out what is the meaning of capacity of contract as per the law of the contract. As per section 11 of Indian Contract Act, every person is competent to contract who is of the age of majority according to the law to which he is subject, and who is of sound mind and is not disqualified from contracting by any law to which he is subject. So there are certain points in this definition that I will break in order to make you understand. So based on this definition, check out what are those points that is included in this definition. The first one is saying that one who is of the age of majority, means a minor cannot make a valid contract. And who is a minor? Who is a major? A person who is supposed to be attained his age or her age of 18, then he is a or she is a major. But below 18 person is minor. So below 18 person cannot participate in a valid contract. Anyway, that contract is void ab initio. So there is no excuse to make that contract valid. That is void ab initio. Okay, but here you need to focus on 2 points. The first one, that is, if a minor is appointed a guardian, in that case his majority will be considered from the age of 21, not from 18. Okay, so you need to focus on this point, that is age 18 and age 21. Without guardian, a person become an independent or major after attaining the age of 18, but with guardian that person will become major only after age of 21 years. So this point is clear. The second point that you need to again focus on, that is talking about the exception when a minor can make a valid contract. Focus, I said a valid contract. How? That is, say if a minor made a contract with a major, means A and B. A is a minor, he promised to buy B's bike and B is ready to sell his bike at the price of 10,000 rupees. What A did, who is a minor, paid the 10,000 rupees. Now B refused to give the bike and he claimed that A is a minor, so this is not a valid contract, and he wanted to take undue advantage of this. But in this case, it is talking about the benefit of the minor, and minor has performed his part as he paid the 10,000 rupees. So in this case, the contract is valid and it is enforceable. So B has to give the bike, otherwise he will be punished by the court of law. Okay, so this is the exception in which a minor can make a valid contract. Now the next point of that definition, that is a person of sound mind. What does it mean? That a person who is capable to make his or her decision. Only he or she can participate in a valid contract. So first one, that is measure, that has to be there. It's not either. He or she has to be measure, as well as, not either, I am just repeating, not either, rather as well as of sound mind. Means he or she can take his or her decision independently and having no medical or health problem. Okay, so a lunatic person cannot participate in a contract. Okay, so he has to be or she has to be of sound mind, a capable person. Next point, that is a person who is disqualified by law to which they are subject. What does it mean that a person who is disqualified by the law? It means you are a measure and you are of sound mind. Even then, if law disqualifies you, like you are a convicted person, okay, you are insolvent in certain condition, and insolvent is not allowed to make a valid contract. So in this condition, the contract is void because you are not allowed by the law to make the contract. So likewise, there are three provisions, there are three essential elements that has to be there to define the capacity to contract. The first one must be measure, the second one must be of sound mind, and the third one, he shouldn't be disqualified by the law. He must be a legal person and having the right to contract. Okay, so these 3 points are essential points to make a valid contract. Okay, now the next point that we have here is, what is a sound mind for the purpose of contracting? Again, though I explained now, just we study it in detail. A person is said to be of sound mind for the purpose of making a contract if at the time when he makes it, he is capable of understanding it and performing a rational judgment as to its effect upon his interests. So, a person who is supposed to be able to understand what is wrong, what is right, and what is the matter of his benefit or his something like deficit. So, if a person who can appreciate all these things, considered as of sound mind. Now, see, this provision further explains this term, that is a person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. What does it mean that? Understand it with an example. There is a person A, he is something like suffering from some mental illness, and sometimes, not frequently or maybe frequently, sometimes he loses his mind and he is not able to make any decision or what he is doing. He has no consciousness, no sense of making any decision. So such type of person during that phase when he is of unsound mind cannot make contract, but when he is okay and he can make a right judgment, at that point in time he can make the contract. So suppose 2 phases, one phase he is of unsound mind, during that phase he cannot, and the second phase, as he enters in the second phase, that is of sound mind, then he can. So that is a valid contract in that case. Second provision, that is saying a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. This is other way around of the same point. First time it was saying that the person is of unsound mind, but occasionally he becomes sound mind. This time it is something like vice versa. So during that phase when he is of unsound mind cannot make, but when he is of sound mind he can make the contract, and that is valid contract. The last point of this provision, that is a person who is disqualified by the law. So if law disqualified someone, like convicted someone, or a person who is alien and enemy, a person who is insolvent. So these persons are disqualified by the law. So they cannot make the valid contract. Now we have the last point, that is very interesting point, that is doctrine of restitution. Well, if you remember, you have studied the restitution of conjugal right. So here we have the doctrine of restitution. What does it mean? That you have contracted with a minor. As he misrepresented himself, he told you that he is a major and all, and you contracted with him. You ready to buy his property, you paid the amount like 50,000 rupees, but later on one of his close relatives, of minor's close relative, claimed that that is not a valid contract because he is a minor. In this case, court can give you the restitution in terms of asking that minor to pay your money, that is the 50,000 you paid to him, but that is limited in the sense whatever the amount that you can get from him, that is only allowed to pay you back. Otherwise, if he already just lost that amount or bought something or maybe just spread that amount in some way, so you cannot claim that amount. So whatever with him, only you can get that. So that is talking about the doctrine of restitution. So this is all for the concept of capacity to contract. We have studied the meaning and concept of the contract. We have also studied something in detail regarding the essential elements of the capacity to contract and the doctrine of restitution. I believe you must enjoy this video, and see you in next video.